going to be 10 has been rejected by the trial court. For that reason, this petition is. And may kindly come to page 16, that is annexure P1, plain. And in the plain draft, I'm reading from the top line.
Yes.
Thus, at the time of his death, Shri Hanuman Prasad Nigam had property owned by the joint Hindu family as described in the annexure 1 schedule of property. Now, my lord, kindly come to page number 20, because the lineage is Banwari Lal, Hanuman Prasad, and Suraj Prasad. Thereafter, the dependent number 1. Now, my lord, at page 20,
Yes.
the amended paragraph is that the second additional district judge in its award dated 15/9/2009 passed in miscellaneous judicial case number so and so, in which in issue number 9 and 13 held that will alleged to have been executed by Suraj Prasad in favor of Srimati Kamlesh is found to be illegal and void, and that Srimati Kamlesh, by taking benefit of ill health of late Suraj Prasad, prepared a false will in our favor, which proves that the property was ancestral property of late Suraj. So Kamlesh is the mother of the plaintiff. So that she is admitting in the claim that will have been disproved by the award. That award is not annexure P7, and that is at page 68.
68.
Yes.
Yes.
You have may kindly come to page 89 of that. Para 32. इस प्रकार उपरोक्त विवेचना से कमलेश निगम की ओर से यह प्रमाणित नहीं किया जा सका है कि वसीयत वास्तव में उनके पक्ष में आवेदक सूरज प्रसाद द्वारा निष्पादित किया गया था। इस कारण वाद प्रश्न क्रमांक 8 अप्रमाणित में निर्णित किया जाता है कि वसीयत प्रभावहीन तथा शून्य है। इसी प्रकार वाद प्रश्न क्रमांक 13 को भी आपत्तिकर्ता के पक्ष में प्रमाणित पाया जाता है कि कमलेश निगम तथा उसके पति अरुण कुमार निगम द्वारा सूरज प्रसाद पर अवैध प्रभाव रखकर वसीयत कराया गया था, जिससे वसीयत शून्य। में काइंडली कम टू annexure P8. Annexure P8 is not linked with along with my application.
This order was passed on an application under section 18 of the Land Acquisition Act.
Reference code.
Yes.
And against this, an appeal is pending in the High Court.
Yes.
Now, may kindly come to annexure P8. That is the deposition of
P8. Annexure?
Annexure P8, not that was filed subsequently along with my application. Idea number 14898.
Yes, P8 is there.
Yes. Now, may kindly come to para 30 of this deposition. Para 11. Last 3 lines from director. स्वतः कहा मेरे उक्त दादाजी को मिली उक्त संपत्तियां उनकी मृत्यु के बाद मेरी मां कमलेश निगम को मिली है, जिसका उल्लेख मैंने दावे में किया है। शी इज एडमिटिंग कि सूरज प्रसाद निगम को जो प्रॉपर्टी मिली थी उसका उल्लेख इसमें है, और कमलेश निगम मेरी मां को मिली थी, वो वाली प्रॉपर्टी जो विल सिवाई थी। विल हैज बीन डिस्प्रूव्ड। मेरे दादाजी सूरज प्रसाद निगम को मिली उक्त संपत्तियां उनकी मृत्यु के बाद उनके द्वारा निष्पादित वसीयत के आधार पर मेरी मां को मिली है। मुझे वाद प्रस्तुत करने से पहले उपरोक्त की जानकारी थी। दिस इज रिगार्डिंग विल। ना बोलो निकांडी कम टू पैरा 13। वाद प्रस्तुत के पैरा 11 में दिनांक 8/12/21 को मेरे द्वारा जो संशोधन पेश किया गया उसकी जानकारी मुझे स्वतः है। वाद पत्र में पैरा 11 में कहे गए कथनों के अनुसार इस बात की आपको जानकारी है कि सूरज प्रसाद की मृत्यु के उपरांत वाद पत्र में दर्शित उनकी संपत्तियां उनके सभी पुत्र पुत्रियों के हाथ में उत्पन्न हो गई। वर्ष 2009 में मेरी मम्मी के हिस्से में जो संपत्ति मेरे बाबा से मिली, जो न्यायालय द्वारा शून्य घोषित की गई थी, इसलिए सभी संपत्ति को पैतृक संपत्ति में काउंट किया है। मुझे नहीं पता कि उक्त न्यायालय द्वारा शून्य घोषित करने से सूरज प्रसाद निगम की सभी पुत्रियों का एवं लक्ष्मी प्रसाद निगम के पुत्र पुत्रियों का हक उत्पन्न हुआ या नहीं। मिलक में करने को पैरा 35।
Yes.
यह कहना सही है।
Paragraph
पैरा 35।
35.
Yes, yes.
There are total 34 paragraphs.
There is paragraph 35. That is along with my application.
Another application.
Another application.
Yes.
For application.
Application IA number 14898.
$35, yes.
मेरी
हाँ, पढ़िए.
ये कहना सही है कि मैंने बंटवारा देना 2361 प्रदेश D1 में जो सूरज प्रसाद निगम को बंटवारे में एक तिहाई हिस्सा मकान नंबर 211 मनाताल में मिला था, उसमें भी अपना 1/4 हिस्सा अपने दावे में शामिल किया. तो शी इज एडमिटिंग दैट शी इज क्लेमिंग 1/4 शेयर इन द प्रॉपर्टी दैट वाज रिसीव्ड बाय सूरज, एंड सूरज प्रसाद इज द फादर ऑफ डिफेंडेंट नंबर 1. So when this is the position that the property of Suraj Prasad is there, so all the brothers and sisters, siblings of the defendant number 1,
Yes.
they are the inheritors of that portion of the property. So सूरज प्रसाद से जिनको भी मिली है प्रॉपर्टी, वो खाली अकेले के नहीं हो सकते डिपेंडेंट नंबर 1. सूरज प्रसाद की जो प्रॉपर्टी मिलेगी वो उनके सभी लड़के और लड़कियों को मिलेगी. ना so far as the petitioner is concerned, he is son of one of the daughters of Suraj Prasad, who is now no more. So therefore my humble submission is that I am a necessary party because I am one of the inheritors.
Your 110 has been rejected.
That has been taken. And that interim order is Annexure P6, madam.
Yes.
At which
65. P6 page 65.
yes,
Read from paragraph 3,
yes,
page 66.
yes. नंबर 21 से उभय पक्ष के तर्क पर विचार एवं अभिलेख से प्रकट है कि वादी ने वर्तमान वाद उसके दादा सूरज प्रसाद निगम की संपत्ति में से जो हिस्सा उनके पुत्र प्रतिवादी क्रमांक 1 अर्थात वादी के पिता अरुण कुमार निगम को प्राप्त हुआ है, ऐसे अरुण कुमार निगम के हिस्से की संपत्ति को उसके पुत्रगण द्वारा व्ययन करने का प्रयास करने से वादी ने उक्त संपत्ति विभिन्न मकान में स्वयं का हिस्सा होने बाबत वाद दिनांक इतने को प्रस्तुत किया है. प्रस्तावित पक्षकार द्वारा प्रस्तुत एनजेसी नंबर 1600 अधिनिर्णय दिनांक 1600 की प्रतिलिपि की प्रतिलिपि के फोटोकॉपी प्रस्तुत किए, जो सूरज प्रसाद निगम की भूमि खसरा क्रमांक इतने की भूमि एजुकेशन विभाग द्वारा तालाब के लिए अधिग्रहित करने के संबंध में देय मुआवजे के संबंध में है. उक्त अधिनिर्णय द्वारा उक्त भूमि के संबंध में देय मुआवजे में उक्त सूरज प्रसाद निगम के एक पुत्र स्वर्गीय लक्ष्मी प्रसाद को व वर्तमान प्रतिवादी क्रमांक 1 अरुण प्रसाद को प्रत्येक 1/8 हिस्सा एवं शेष पुत्रियों को 1/21 भाग प्राप्त करने का अधिकारी होना निर्धारित किया गया. इस प्रकार उक्त एनजेसी भू अर्जन के तहत उल्लेखित कृषि भूमि के मुआवजे वितरण के संबंध में है, जबकि वर्तमान वाद कृषि भूमि से संबंधित नहीं होकर प्रतिवादी क्रमांक 1 के नाम से दर्ज संपत्ति विभिन्न मकान इत्यादि में पुत्री होने के नाते वादी का हिस्सा होने बाबत प्रस्तुत किया है. ऐसी स्थिति में उक्त भू अर्जन प्रकरण दिनांक 1600 के आधार पर प्रस्तावित पक्षकार वर्तमान प्रकरण में आवश्यक पक्षकार होना प्रकट नहीं है. ऐसी स्थिति में प्रस्तावित पक्षकार की ओर से प्रस्तुत न्याय दृष्टांत 1600 का से कोई लाभ प्रस्तावित पक्षकार को प्राप्त नहीं होगा. इस कारण प्रस्तावित पक्षकार का उक्त आवेदन आदेश इतने निरस्त किया जाता है. My humble submission is that in the partition, whatever was received by Arun Kumar Nigam, that is a different issue. But the Suraj Prasad Nigam, he executed a will in favor of wife of Arun Kumar Nigam.
Yes.
That will has been proved to be not legal
Yes.
by the reference court. That judgment is there, and the learned trial judge has misunderstood that position, factual position. That how that reference court's judgment has to be seen. That has to be seen only with reference to the rejection of the will. Once the bill is rejected,
The land is different so far as.
no, then this in para 35 she says कि सूरज प्रसाद निगम की जो संपत्तियां हैं वो भी मैंने इसमें शामिल की हैं। क्योंकि सूरज प्रसाद निगम को जो संपत्ति जो सूरज प्रसाद निगम ने अपनी बहू को दी थी कमलेश निगम को, वो वाली बिल जो है वो बिल रिजेक्ट हो गई बाय द सिविल कोर्ट। So therefore, now the property again goes to Suraj Prasad Nigam. So all the children of Suraj Prasad Nigam, they are the inheritors, direct inheritors. Now, Lord, in this regard, Lord, I humbly submit that I rely on your this. Para 19, 20 and 21. Para 19.
Yes.
As already discussed here in above, the plaintiff himself has admitted in the claim that the property is jointly owned by the defendant as wife and children. A specific objection was also taken by the defendant in his WS with regard to non-joinder of necessary parties. Since the truth property was jointly owned by the defendant along with his wife and three sons, an effective decree could not have been passed affecting the rights of the defendant's wife and three sons without impeding them. Even in spite of the defendant taking an objection in that regard, the plaintiff has chosen not to impeach the defendant's wife and three sons as party defendants. And so far as the glance is by so and so. Now, we can't come to Annex 20. It can thus be seen that what has been held by the court is that for being a necessary party, the twin test has to be satisfied. The first one is that there must be a right to some relief against such party in respect of the controversies involved in the proceeding. The second one is that no effective decree can be passed in the absence of such a party. Now, this position has been summarized long back by Allahabad High Court.
Yes.
I'm referring to AIR 1989 Allahabad 163.
One 168.
Yes.
Paragraph.
Paragraph 10 and 11. In 10, the High Court has noted about the case where it is said that plaintiff is the dominant latest. For that, that point has been discussed in para 11. So, Lordship may kindly read. From with profound regards, I may say that it can never be a principle which may be made applicable in every case in view of the wide sweep of the language employed in Order 1 Rule 10.2 of the Code. The provisions of Order 1 Rule 10.2 of the Code clearly empower the court to include any person as party to motto who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit. In case the plaintiff is permitted as a rule to choose his own opponents and the court does not interfere on the point, in that event, it may be that a collusive decree is obtained against the real owner or interested person without impeding him as a party, and when the decree will become final, then at a very late stage, the person vitally affected or the real owner may come to know about it. This would lead to defeat the interest of justice, which should not be permitted in the court of law, and to avoid these ugly situations, the Parliament, with considerable ingenuity, enacted Order 1 Rule 10.2 of the Code, which has been couched in a language having very wide sweep. Now, in another case, ILR 2016, MP 418.
148.
418. Para
You listen.
15.
You had supplied list of books.
I think my plan must have supplied. I was under the impression that we supplied them. Not, I apologize for that.
इसका पैरा बताइए ILR का।
Minute para 15, 1 time.
Yes.
May I read now?
Yes.
In the opinion of this court, it was proper and necessary for the petitioner to have implemented the intervener as the defendant in the present suit, as without giving an opportunity of hearing to him just and fair adjudication of the civil suit is impossible. So it cannot be laid down as an absolute proposition that a third party can never be implicated in the suit, but where the third party can show a fair semblance of title or interest, he can certainly file an application for impeachment and ought to be implicated as a party. In other sense, it would avoid and prevent multiplicity of proceedings. The second part of Supreme 2 of Order 1 to 10 empowers the trial court to add a person who ought to have been joined or whose presence before the court may be necessary in order to enable the court to adjudicate upon and settle all the questions involved in the suit. This is actually the aim and object of the provision contemplated in Supreme 2 of Rule 10 of Order 1. Another case on the point is PIR 2010 April 3109. I'm referring to para 12 and 12.3, where the scope of Order 1 Rule 10.2 that has been discussed.
Yes.
In your para 12, let us consider the scope and ambit of Order 1 Rule 10.2 CPC regarding striking out or adding parties. Some rule is not about the right of the non-party to be implicated as a party, but about the judicial decision of the court to strike or add parties at any stage of the proceeding. The discretion under the sub-rule can be exercised either suo motu or on the application of the plaintiff or the defendant or on an application of a person who is not a party to the suit. In exercising its judicial discretion under Order 1 Rule 10.2 of the court will of course act according to reason and fair play and not according to whims and caprice. Somewhere in para 12.3, it is said, if a person makes an application for being impleaded contending that he is a necessary party, and if the court finds that he is a necessary party, it can implead him. If the plaintiff opposes such impleadment, then instead of impeding such a party who is found to be a necessary party, the court may proceed to dismiss the suit by holding that the applicant was a necessary party and in his absence the plaintiff was not entitled to any relief in the suit.
Yes.
Why? So that on the basis of these cases, I humbly submit that there is one more case of Bombay High Court. I want to kindly come to para 20. The theory of
Yes.
The theory of dominant status cannot be overstretched in the matter of impleading of parties, which results in ineffective decrees being passed in absence of necessary parties, or where the theory is misused to deliberately obtain decree against non-interested persons, officials, and then use it to assert rights of plaintiff. It is also for the court to ensure that the real matter in dispute is effectively decided by impleading all those who are necessary parties merely because plaintiff does not choose to implead a person is not sufficient for rejection of an application for being impleaded. If the court feels it appropriate that any particular party's presence is necessary before the court for adjudicating upon the issue involved in the suit, the court has full power under Order 1 Rule 10.2 of the court to direct addition of such party to the suit. So the theory of dominant status, that is something different when it comes to Order 1 Rule 10.2. That is my investigation. So my humble submission is that this application has been wrongly rejected by the landed court. He has not even discussed whether I am a necessary party or not, in view of the admissions made by the plaintiff in our deposition.
Yes.
Let me kindly see the petition notice where the family tree there in page 5 of the petition.
Yes.
बनवारी लाल,
Yes.
हनुमान प्रसाद, सूरज प्रसाद निगम। देन सूरज प्रसाद निगम को आप देखेंगे, एलपी निगम, एके निगम, चंद्रमुखी, इंद्र देवी, शशि देवी एंड सुमन।
Yes.
सुमन के ये लड़के अपने आप को बताते हैं।
We'll continue after break.
65
What did you mention?
नंबर 60 है। I mentioned serial number 60. Wait,
For the request list, मैं